Lower Perak Co-operative Housing Society Berhad versus Ketua Pengarah Hasil dalam Negeri. The fact of the case is appellant for this case is Lower Perak Co-operative Housing Society Berhad, which is a housing cooperative society registered on 8 September 1955 under the Cooperative Society Ordinance 1948. Meanwhile, the respondent for this case is Ketua Pengarah Hasil dalam Negeri, Director General of Inland Revenue. In 1956, the appellant purchased approximately 142 acres of land amounted 103,312 ringgit 50 cents. Appellant intends to develop 142 acres of land and construct buildings for sales to its members. However, due to low demand, the appellant only sold 41 building lots in 1971 and 407 lots in 1973 to a developer. Then, the profits from these sales were assessed as taxable income by the IRB, but the appellant contend that these profits were capital gains and not subject to income tax. The issue for this case is whether a taxpayer carries on a business is a question of fact, but when there is a misdirection in determining the fact, it becomes a conclusion of law. This means the determination of whether the taxpayer, which is Lower Perak Sdn Bhd, was engaged in business is initially a factual matter. However, if the tribunal or the decision maker applied a wrong legal principles or misinterpreted the fact in reaching their conclusion, the matter transcends into a legal issue which makes it subject to judicial review or appeal on a point of law. The issue arises because of two reasons, which is the cooperative claim that the sale of the land was not a business activity, instead it was a realization of a capital asset. Second, the tax authorities argued that the transaction demonstrated a systematic profit-making scheme to business activity. The judgment for this case is court held answering the questions in the negative manner and allowing the taxpayers appeal. In an appeal to the Special Commissioners, High Court or Supreme Court against an assessment made under the Act, the onus is on the taxpayer to show that the assessment should not have been made. In this case, stated that it is the court's duty to examine the Special Commissioner's determination having regards to the law. If there is anything ex facie which is bad law or where no person could have come to that determination or where it is not supported by evidence or is consistent and contradictory of it, the court must intervene. The Special Commissioners has misdirected themselves by making the findings that the land was stock in trade and not an investment, because it was wholly inconsistent with their earlier finding that the taxpayer's primary purpose in acquiring the land was to build houses for its members. The nature of the transaction must be determined from the point of view of the taxpayer, and a mere sale at a profit is not a trading activity. The Special Commissioners had erred in holding that the mere acquisition and sale of an asset resulting in a profit constituted trading or an adventure in the nature of trade. Whether the taxpayer was trading when it entered into the agreement with the developer depended on the taxpayer's intention and whether it remained the same. The guideline principles are: first, the form of documentation and terms; second, the paramount object of the transaction, for example, whether it had a commercial purpose or not; third, the subjective intention and motive of the parties, for example, whether there was an intention to make a profit or not; lastly, only one party may be trading but not the other. For example, a person is not trading when he merely procures someone a trade. The implication for this case is it is important to note that the intention at the time of acquiring an asset and the motive of transaction are critical in determining whether profits are from trading or capital in nature. Even if profits are realized, they are not automatically considered taxable if the intention was non-commercial. Next, the court recognized that the sale made under financial compulsion, which is forced sales, lack of requisite intention to trade. This means that the compulsion can cancel trading intention, shielding such transaction from being taxed as business profit and eventually make the appellant not subject to income tax. In conclusion, the taxpayers' appeal against the assessment by the IRB was upheld. This decision overturned earlier rulings that had classified the profit as taxable income from trading. The sales of the land was not subject to income tax and the deposit paid earlier was refunded to the respondents.